rumors spreading round in that Texas town.
Hey, it's the Mikey Man and Randy Show. We're back for week
I'm
something.
Mikey Man.
I'm Randy Man. Anyway, a little bit on vocational expert, a little bit on courtroom drama. Actually, my son told me the other day he wanted to be a lawyer. I just thought about that. He said he wanted to be like on Boston Legal. He said, "Dad, is that what lawyers do? Is that what lawyers are like?" I said, "Oh yes, son, 100%. That's pretty much it."
Yeah, oh yeah. Boston Legal is the most accurate representation of the practice of law that I've ever seen.
I thought so too. Yeah, maybe Grey's Anatomy is just as good. I'm not sure.
Well, Grey's Anatomy is an accurate description of
the practice of law.
medicine.
Medicine. Oh, medicine. Okay.
Yeah. But Captain Kirk is a great lawyer, I have to tell you.
Yeah. He must be. He's advertising on our
Denny Crane.
Yeah, he's on our TV all the time. Well, anyway, we thought we'd take you to the courtroom and introduce you to the cast of characters that you're going to run into as an expert witness. What do you think?
I think that's a good idea. You know, we've talked about how there are. No, actually, we haven't talked about how there are different characters in the court. Now, what characters are there? I mean, who are the major players in the courtroom? I mean, we know who the vocational experts are because that's what we're going to talk about.
Right.
But you have to be cognizant if you're going to do this kind of work of who does what and how things are laid out, and so that's why we're here today.
Okay. Well, let's go look at the different ones and see who's up. Well, the first character we have at the court that you're going to run into is the judge, because the judge, who is also known as the trier of fact, or one of the two people that would be known as that, one of the two entities, would be sitting up at the front of the room. You'll notice that they're always on what's called a raised dais, I believe that's what it's called, where they're up higher than everybody to make you feel and look a little more insignificant. Also, though, when you walk up, you'll notice that the person walking up is on eye level or below of the judge.
Order in the courtroom.
When you come into the room, the judge may be talking to somebody or doing something, and you show judicial respect by staying back from the bench, particularly if you have a weapon on you. But anyway, stand back from the bench and not walking up until they tell you to go up. And generally before you sit in the witness chair, the judge will invite you to sit down. And then when you're done, he might invite you to get up and you'll be dismissed. But you certainly want to follow the lead of those around you. If the judge is out of the room and comes in, you stand up when they walk in. If they get up to leave the room, you stand up again. And it's always a matter of respect.
Wait a minute. And they'll never look the judge straight in the eye or they'll turn to stone.
He didn't hear that. He said, "Don't look the judge in the eye or you'll turn to stone," which may be true. All right, well, let's go look at at someone else.
One of the other players is the court reporter. Court reporters are usually pretty little things. Oh, but that would be sexist and harassment. But the important thing about the court reporter, there are several things. One of which is they always want to know what your name is. And if you've got a name like McClanahan, you're probably going to have to end up spelling it. The court reporter or the judge is usually the one who's going to swear you in. So that before you would take the stand, you would raise your right hand, usually standing, and they would ask you if you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. And you would say, "I do." And then you would sit down. Anytime you are giving testimony and you reference technical terms or a lot of the tools that we use, sometimes the court reporter might even stop you and ask you to spell it. Just be aware of that. But that's one of the things that they do. They also, sometimes along with doing the stenography that they're doing, like she's doing right now, some of them will actually hold a cup to their mouth and talk into a machine that digitizes the voices and puts it on tape as well. Just like that.
Of course, your reason for being here is to be an expert witness, and when you're an expert witness, they have a witness box. It's generally right next to the judge. Will either be next to the jury or facing the jury. And one of the things that's interesting about the witness box, you don't go in it and sit down and again until you're invited. Usually you stand up give the oath, either with the judge or the court reporter. Then you walk up and sit down in the witness box, and then you sit there until they start asking you questions. You don't volunteer, you just wait till they ask questions. One of the things about a witness box that's always true is they're uncomfortable. Usually the chair's bolted to the floor, you're not at a good angle. Sometimes there's a mic that either won't work or is way away from you or sticks right into your face. But anyway, you just kind of have to get used to the witness box area, and you can spread your things out in front of you and work. And then the attorneys will stand back at their table or at a lectern and ask questions, and you respond to the attorney. One of the things that we've talked about is who do you look at? You don't necessarily want to look at the attorney when you're answering the questions. You might want to look at the trier of fact, whether it's the judge or the jury, and respond to their questions. I often find that judges will have their own questions when the two sides get done with you. Now let's go over and take a look at the. That's got to be the dullest witness I ever heard. Hey.
Lunchtime yet?
He's still talking. He's still talking up there.
He's going forever.
Most boring guy I ever
Why
heard
do
in my
I
life.
care? Why do I care?
Sit down. You've got two different attorneys sitting at two different desks. One will be the plaintiff attorney, and generally the plaintiff attorney, well, always they will be the ones to start asking questions first. They get to put on their witnesses in a certain order, and then when they get done with their witnesses, then they bring in the plaintiff witnesses. Typically, they would stand up when asking questions, and they might stand at their desk, or they might come around, like I say, to a lectern. This is the view from the witness stand, though, of the plaintiff attorney asking questions. I object. I object to that. I object to that testimony.
Another player in the case is the defense lawyer, and even though you see him objecting, what you might find is that he is actually objectionable. But those are the two people you're going to be concerned with, along with the judge, in what we call a bench trial. Now, where that's important is that when you're on the witness stand, the lawyer that is asking you questions is obviously not going to raise an objection. But the other side, whichever side that is, the defense or the plaintiff, is going to raise objections. And what you're supposed to do in that case is, as soon as the objection is raised, you stop answering the question and wait for the judge to rule on the objection. If the judge overrules the objection, you go back and answer the question as it was asked. If he sustains it, they either have to rephrase the question or ask a different question, or you start all over again. And in my own case, in my own situation, many times I even forget what the question is and ask them afterwards whether or not they uphold or sustain the objection and what the question was. Okay, in this segment, maybe we could talk about the similarities between bench trials and jury trials.
Okay.
So, I mean, in terms of what our role is as experts. I mean, for example, in both trials, there's going to be a judge.
Right.
There's going to be a plaintiff attorney. There's going to be defense attorneys. There's always going to be a court reporter.
Right. That's kind of the basic minimum, right?
Exactly.
Even in administrative law hearings, you're going to have that kind of stuff.
You have all the exact same, except for with ALJs or administrative law judges, you don't. In Social Security hearings, you don't have a defense lawyer.
Right.
Because I guess the ALJ takes that role. But in a courtroom, which is where we are today, those characters are always going to be the same. And for the most part, your testimony would be very similar. But for me personally, one of the things I've found is that judges, when you have what we call bench trials, single deciders of fact, I don't know if you found the same thing, but judges are usually less impressed by people like us than juries are. Has that been your experience?
Oh, absolutely. Well, let me back up just a minute. Judges have heard all this before. They've heard it many times. And so they have to endure sitting through every time we come in and have to, first of all, give all the background of our great and glorious histories and publications and all. So they're not impressed with it. They're not even listening to most of that stuff. So once we then get qualified and we're on the stand, well, they qualify us on the stand, but they give us time to testify. generally they want to hear a few things, and all the rest of that stuff they could care less about. So I've had several of them look like they were bored out of their minds, or they were doing other work. They're talking away and looking at them, they're doing other work, and then they'll turn to me and say, "Now, what was that rating again?" I'd say 38% or whatever it was.
Yeah.
And they're interested in that.
Yeah.
Is that your experience?
Yeah, very much. And when you have a judge who is a single decider of fact, or again, what we call a bench trial,
Mm-hmm.
he's the one you have to impress, he or she. That person
right.
sitting in the chair is the one you have to impress if you want to impress anybody. Now, I could tell you that along the lines of judges having seen a lot of us, and sometimes too much of us, I had a trial several months ago where I was hired as the vocational expert, and it was against the city of Montgomery. And everything I'm about to tell you transpired in an open courtroom, so it's legal. There's not a confidentiality issue here. And the city, which was the city of Montgomery, hired a vocational expert by the name of John McKinney, one of your students.
One of our graduates.
And he was in a class I taught as well. So I've always liked John McKinney, and so John, if you happen to get this, I like you. But when we talked about different, and John and I had different findings. You'll never guess what my finding was.
You were 100%. I'm
There
sure.
we go.
Yeah, completely. Never work again. And who hired you?
The plaintiff.
The plaintiff
did, yes.
side. That's right. Because they can make more money if a person was 100%.
100%.
Okay,
That's
now,
right.
That makes sense to me.
Which is especially true in the state of Alabama. Now, state laws vary,
Right.
and your settings are going to vary. But in every state, the things that we've told you so far in terms of the layout of the courtroom, those are almost always consistent. I mean, the players are always going to be what we've talked about. But in that particular trial, there was a disagreement. I had 100%, and John had something like 68, 70%.
5.
And so,
5%.
yeah, 5%.
Representing the defense, and it'll save us money if we're low.
Well, in low, in that particular case, was anything less than 100%.
Right.
As you know,
Right.
the 100%, the 99%, if it were adopted, would be on a 300-week pay schedule, whereas 100% would be on a lifetime benefit. So it was a difference of hundreds.
Hundreds of thousands
of
probably.
dollars.
Right.
Yeah, exactly. And so, to show you that the judge was not so impressed, we got into the methodology, and John was saying that Dr. McDaniel taught him this, and he had coached his lawyer to ask me the same questions. Did Dr. McDaniel teach you the same thing? And of course, I said no. He didn't to teach me anything. In fact, he didn't teach me anything at all. And so, toward the end of the trial, the judge said, you know, if whoever doesn't mention the name of Dr. Randy McDaniel again will win this case. He didn't want to hear any more about Dr. McDaniel because he'd had experience with McDaniel.
The judge said that?
Didn't go so good. No, yeah. It's something about overbilling and, you know.
It was a bad experience.
Yeah, bad experience.
Oh, that's bad. That is bad. That is
Yeah,
bad.
he just didn't want to hear your name anymore. So
I'll tell you the one thing about that, and this is my favorite thing that ever happened to me, is I walked into a federal case, and the judge is one I worked for when he was in practice. I had done cases for him.
yeah,
I had been in front of him before on the bench when he was on the bench, and he liked my testimony, or at least he ruled in the way I testified, so I guess he did. And I was working for one of the attorneys, and I had worked for the other attorney.
wow.
Now that's
credibility,
That's
too.
only happened once, but it was so great because all of a sudden all the formality was gone, all the extra nonsense was gone, because they all knew me and I knew them, and we just kind of cut to the chase.
And they listened to your testimony anyway, didn't they?
You know, they actually did. I don't know if they went with it that time. I don't remember. But it was interesting because when you first get there, a lot of the qualifying you and they ask you all these questions to make you sound like you're just such an expert. We just did away with all that because they all knew me. We just did away. They knew I was foolish. I didn't need any of that.
Yeah, so judges, I mean, they as they say, it's not their first rodeo. So
No,
and sometimes it's hard to find something to say to them that's going to resonate with them.
that's true. That's very true.
But,
I love it when they finally quit doing their work over there and they turn and they say, "Y'all done?" Meaning that the plaintiff had finished examining you, cross-examining you, and then they turn and say, "I've got a few questions."
That's usually a good sign.
That's
if
a
you
good
ask me.
sign. That is a good sign because they'll listen to your answers, and they may, you may think you're talking to, I don't know, somebody off a hee haw. The way they'll say, "Well, ain't it true, Dr. McDaniel, that fools out here that whatever they say, it does not matter. You know, if you can just answer their questions and be perfectly honest. I'll give you an example of that. And the guy wasn't off hee-haw. The guy
Perfectly
was,
honest?
no, he was very smart judge.
What's perfectly honest?
I was on a federal
Honesty
case.
has no role in the courtroom.
Well, you know, what can I say? I was with a federal judge, and so I was giving my testimony, and this doctor had given stuff to us, and he said, this claimant is 100% disabled, can never work again. That's all he said. So, you know, I get up, it's my plaintiff role, and yes, Judge, I believe this plaintiff is 100% disabled. He'll never work again. He said, you taking that some from the doctor? I said, oh yeah. He said, that doctor didn't give us much help, did he? And I said, you know, he really didn't. If he would have just told us what his restrictions were, we could have dealt with that. But just for him to say 100% disabled, it doesn't mean much to me. And the judge said, it doesn't mean much to me either. But I mean, we were just at a very honest kind of a moment there that I think helped him in making his decision.
And that's a good point, because a lot of times you feel like you're an advocate when you go into the courtroom, and we're not supposed to be an advocate.
We're not
supposed to be
advocates.
objective.
We are not advocates. The attorneys are advocates.
Exactly.
We are not. We are impartial witnesses.
But I will say this, I do find myself as being an advocate of my own opinion. And in
Right.
that I want to be able to support that in any way that I can. So when we talk about things that sound slanted one way or the other, we're really trying to get that point across as not so much as advocates, but we want to have credibility from the witness
Right.
stand, and that's what's really important.
You know, I sit in on somebody's trial. It may have been yours. It may have been one of yours where you were with. No, I sat in and watched the witness. I don't remember who it was, McLean. But the person, it didn't matter how they were approached by the opposing counsel. They held their position like, you know, I can't budge on this, to the point that everybody in the courtroom was watching and said, you know, they're such an advocate, they're not being objective. I mean,
Right.
it was so obvious, and at that moment, they honestly lost any credibility. I think anybody quit listening to them.
And what happens there? It's the baby with the bathwater. I mean, because they held on to their position so firmly, and without reason, the rest of their testimony was probably going to be thrown out, or at least viewed as uncredible. Whereas the one thing, because I've had lawyers who hired me, put me on the stand, and they would ask me a question, and the answer that I gave them was not the answer they wanted, and they didn't expect it, and that does happen sometimes. But sometimes the lawyer will then say, "Well, Judge, I told you that my witness is going to be honest," and so it really helps you in cases like that to listen to the question. Sometimes you do have to forget about what your opinion is
Right.
and answer that question.
Right.
Honestly, because if you get backed into a corner where you're, once you tell one small untruth or inconsistent thing, pretty soon that lawyers are expert at getting you to go completely 180 degrees in the other direction by forcing your testimony. So
I wouldn't know about that.
yeah, no, yeah. No, but I think, you know, like I said, you, and the other part about that is if you're hired by a plaintiff lawyer. And while he's asking questions, and if your answers are always yes, then when the defense lawyer gets up and your answers are always no,
Right.
there's something wrong with that.
Something's not right
Yeah,
there.
yeah.
Right.
And so you
So
want-
have you ever changed your testimony?
I change my testimony all the time. Yeah,
Do you?
and when they bring
Depends on who pays you.
depends on and if they pay me enough.
Which way the wind blows.
Yeah.
No, I'm serious. I mean, you get asked questions in a different way, or a little, and you've changed with that, or
Yeah, let me give you an example.
Okay,
I've
good.
had like I may say I think that since we're calling me 100% McClanahan, I may say that the person's 100% disabled.
okay,
Then if the lawyer comes up and hands me a functional capacity evaluation, for example, and says, okay, now if the judge believes this functional capacity evaluation over other evidence in this case, do you still maintain that the person is 100% disabled?
and you would say yes.
I would always say yes. No, I mean, then I would say, oh, no, of course not.
Right.
My opinion
Right.
would be then, in light of that evidence, that his vocational disability rating would be something. Now, and even then, I mean, sometimes I can say, I know that it would be less than 100%. I don't know how much it's less because I don't have the ability just to calculate it here from the witness stand. I mean, it would just be.
So then they would probably ask you, well, would you go?
Yeah.
Would you agree that the experienced Dr. McDaniel that taught you everything you know, that you might say that whatever he says?
And I would say
is
I
correct.
completely defer to Dr. McDaniel. He is so much smarter
I thought
than
you would do
anybody
that.
I've ever known in my whole life.
That's right.
I would believe everything that
No,
he
so
says.
I'm the hidden witness that comes
Yeah.
out next
Yeah.
to
Yeah.
testify. I mean, they do ask, I'm playing around, but they do ask you stuff like that.
They do.
You know, would you defer, what do you think about so-and-so? And you say, I think he's great. I don't really ever not said anybody was great. And then they'll try to spring that on you if you don't watch out.
But what you don't want to do is defer to anybody else on your area of expertise.
Exactly.
You can defer about medical things. You can
Right.
defer about factual bases in a case, or things like that. But I would not want to really defer to Dr. McDaniel or Dr. Sink or somebody else that's on the other side. And I also would not want to defer to when they give an authoritative resource, because even authoritative resources have conflicts within them a lot of times. So,
I agree.
You could say, I think that's a valuable resource, but I still would not defer as to the basis of my opinion.
You know, the one I get all the time is, well, don't you think that Dr. So-and-so, the treating physician, is in the best opinion to talk about vocationally what he can do? I say, no, he's not a vocational person. He can't talk about, he can talk about it. I certainly would defer to that person for the physical limitations or whatever it might be. The other one I get like that is some doctor that obviously the defense or the plaintiff has hired, that side has hired, and they'll say, well, don't you think this doctor would be the one that would give the best limitations? Or however they'll say it, and no, not necessarily.
In this courtroom, I can recall a testimony that I gave upstairs in a circuit court, where a lawyer asked me if he said basically almost accusing me. He said, "You mean certainly you would not disagree with Dr. Thus and so?" It was Dr. I can't remember his name, but that. It might have been Dr. Rivard, that this person could drive a truck. And I would say, and my response is, oh, of course I would disagree. And besides that, whether or not he can drive a truck is different from asking me whether or not he can be a truck driver.
Yeah.
Because there's more things involved in being a truck driver than there is driving a truck.
Right.
Now, when I offer testimony like that, sometimes in the middle of my sentence, whoever doesn't like the testimony will stand up and object. Because I'm not actually answering the question as it was asked. I'm segueing to another question.
Which is a separate issue. But when they do that, what do? You just keep talking and ignore them, or what do you do?
Well, in a bench trial, you stop.
Yeah.
I always stop.
Yeah.
Because again, this is sort of a difference between a bench trial and a jury trial. And we're going to segue a little bit to differences in bench trials and jury trials. This is kind of a subtle thing. But in a jury trial, and this is sort of underhanded, but they say you can't unring a bell once you've rung a bell.
Right.
So that sometimes if I'm asked a question and the answer to that question is really important to supporting my opinion,
right,
and I want the jury to hear it, even though I'm concerned that they might not be allowed to hear it.
Right.
After the objection, sometimes I'll continue with the objection. I'll continue with my answer until I finised it.
Until they tell you to shut up.
Yeah, or they shoot me or handcuff me and take me out of the courtroom screaming.
But typically, when somebody objects and they'll usually I object and they'll take off into the reasons or what's the problem. Typically, you just kind of be quiet. And matter of fact, I've had that go on 10, 15 minutes sometimes. They're hassling back and forth and all that stuff, and then the judge will finally try to say, "You can answer the question."
And then what do you normally say? What was the question?
Normally I'll say, can you repeat the question? That's usually what I say.
One of the things, too, and I mentioned Jack Sink a few minutes ago, one of the things that I really liked about what he taught me was that he used to say that if a lawyer asks you a question that you don't want to answer, what you can do is rephrase the question back to them as to that's a question that you do want to answer, and you answer it that way. And by what you do is say, well, when the question is asked, you then would say, well, if you are asking me whether or not I personally would adopt this functional capacity evaluation, the answer is yes or no.
Right.
But sometimes that's
you rephrase it and clarify it the way you want to answer
it. Right.
So many attorneys use this technique, and it just drives me up a wall. And they'll say, Dr. McClanahan, wouldn't you agree that today is Thursday?
Yes.
Dr. McClanahan, wouldn't you agree with... And it's like that, and so they try to put you in a yes-no situation. All right, today's Thursday, that's an easy one, but they get into more technical things, and you don't want to be in that. And so you can answer yes or no, or you can just answer and not say yes or no, or I like rephrasing the question back to them. If you're asking me da-da-da-da-da, the other one I run into all the time is multi-part questions, where there's 3 questions in one, and if you answer yes, or no, you've just committed yourself on several different things. And it'll come back around to bite you because they're going to ask you that.
One of the main things one of the main privileges of an expert of any field has over fact witnesses,
Mm-hmm.
and we're called almost always as expert witnesses, is that we're always allowed in every court setting to explain our answers. So that
Right.
have you stopped beating your wife?
Right.
Rather than just answering yes or no, you can say, well, yes, because I've never beaten my wife. But if you're a fact witness, you would have to say yes or no. I mean, it's an implicit question, but and be aware that a lot of times the person who is asking the question, if they don't want to know your explanation of the question, they'll walk on your answer. So, and that's a little touchy thing. You have to decide whether or not you're going to kind of get into a combative situation with the lawyer or not.
I have, and I know you
Yeah.
have. I have too.
I'm
When
bad
I'll
about
say, when I'll say,
No, I haven't. I've never done that.
yes, you have
I
to.
have not.
I know you have. I've watched you do that.
No, I haven't. Just
When-
one time.
well-
See, there was just one time when I was.
Yeah, every time.
Go ahead.
But no, I mean, about what?
Yeah, I don't know.
Could you rephrase the question?
Object.
Could you rephrase the
This
question?
whole thing's this court's objectionable. No, continue. Dr. McDaniel.
There are times when you just have to say, I would like to finish my answer. Can I finish my answer? Or you just, I don't even say that. I don't ask for permission. I just finish it. And you know what? They'll eventually shut up trying to talk over you and let you finish and move on to the next thing.
Right, because everybody actually wants to get the trial over with sooner or later.
Matter of fact, that was the biggest thing to me is, I thought I'm coming in as this expert and I've got all this time and da da da. They don't want to hear it. The judge is put the players under tremendous pressure to finish this thing up. Let's move it along. We don't want to be here through the weekend. We want to hold this jury over a weekend. We want to get out of here by tonight, whatever it is. And so that does shorten up everything, because otherwise the 3,000 questions they ask you in the deposition, they could ask you that again in court, but they're not going to do it. They're just going to get to the ones that they want to bring something out.
Well, let me ask you a question about that. If you're in a, let me make a point and then ask a question.
Okay.
The point is that in a bench trial, if you have experienced lawyers on either side or on both sides, and usually the trial is going to go quick. I've had bench trials,
Right.
work comp trials that were 2
Right.
hours long from beginning to end,
Right, whole thing.
because the lawyers,
All the witnesses, everything.
yeah, the lawyers were smart enough. They got together and there were certain things they could stipulate to, which means agree to, basically, before the trial started, and they know what they're doing. But I've also had trials where the one party or the other didn't really know what they were doing. I had a worker comp trial that went for 2 full days, and the issues were not on liability, but on just the damages,
Okay.
basically.
So you were a star.
Well, no, it was a bad. I mean, yeah, I did okay, but it was a tough deal. I mean, it was rough.
Yeah.
But the question is, have you found that you get treated more civilly by lawyers in bench trials or in jury trials?
Must be, I'm trying to think about it, because I've been badly treated in both, to be honest.
Unfairly.
But generally, in a bench trial where you're just in front of the judge who's heard it all, they shorten everything up. The attorneys shorten everything up. They don't put on the theatrics for the jury. The only theatrics they're putting on is for their claimant, because they want to, whoever their client is, the company or the person, because they want to get, make them feel like they're getting their money's worth. But they don't do all the rant and raving and carrying on. So I've been
Right.
probably worse treated or just oddly treated in front of a jury. The flip side of it, though, because I have been very nicely treated in front of a jury, because the flip side of it is sometimes the attorney doesn't want to come off as the bad person. If they're the bad girl or the bad guy, and they're hammering on you or hammering on the witness, and the jury sees that, the jury may turn against them just because they don't like their style.
Exactly.
So that can happen too.
One of the axioms in a jury trial is that you don't go after a witness. If you're a lawyer, you don't go after a witness unless you feel like you can get him.
Yeah.
In other words, if you have contempt for the witness, if you're the lawyer, and when I say witness, I'm talking about us, the vocational
expert
people,
witness. Okay.
expert witnesses. If you have contempt for them and you can get them in front of the jury, meaning discredit them in front of the jury, you can do that.
Right.
But if you can't discredit them in front of the jury and you just act contemptible towards them, it usually sits poorly with the jury and it angers the jury.
Right.
Juries tend to go with people they like the best.
They do. They
do.
really do. They
Yeah.
really do. And I've seen attorneys make the mistake of getting contemptuous with the disabled person, the person with a disability.
Yeah.
It's the injured party, and boy, does
That backfires.
That backfires
Big time.
Yeah.
Yeah. Yeah. Usually, I've had in jury trials, lawyers on the other side of the case, at least initially, exceedingly kind to me. That they offer me water.
Oh
you know,
yeah, oh yeah,
or,
yeah.
been
Want to
up there a
chat
while,
between
yeah,
things?
yeah, all that kind of stuff.
Yeah.
But they won't necessarily do that in bench trials. I think it's a little bit more of a natural setting where there's not an audience in play.
One thing about all that, and this is something you folks need to keep in mind, there's nothing personal really about this stuff. Attorney can get up in front of a judge or a jury and just chew on you and just do all they can do to discredit you, and then afterwards you can go to lunch together. He doesn't care. It's not
Right.
it's nothing now occasionally it does get personal, but most of the time it's just that's the way they see their job. That's what they think they can be most effective. The one that drove me crazy, we have a guy here in town. He objects to everything. You start a sentence, he's objecting. And after about 30 minutes of that, you want to strangle the guy because he's objecting to everything you're going to say and every word you say and all that. And finally, though, it'll irritate the judge, and the judge doesn't quit. But that guy outside of the courtroom is as nice to me as he could be. But in the courtroom, he's always harassing me that way. And he does everybody. It's not just me.
And I always remember, the thing that I really like about lawyers is they are paid advocates. They are not hired to do justice.
No.
They are hired to advocate their client.
Anything,
whether dirty, clean, it doesn't matter.
Anything for their client is the way they look at it.
And if something comes out bad about their client, they're going to do their best to minimize that as much as they can or get rid of it. There's not justice. And so you always know where they're coming from. There's always, even though we are paid to be objective people, you always kind of are going to see the lawyers. One set of lawyers is going to be wearing white hats, and the other one's going to be wearing the black hats, so to speak.
Usually the one that pays you is wearing the white hat.
Exactly.
Right?
That's the way that usually is.
I got so tickled. I went out with a group of defense attorneys. I was working with them, and we went for lunch between the trial. And they were just carrying on about it, and then they had it made. And boy, did you see how they got that guy and they did this, and it was. And I just kept watching. It was funny. I said, well, that other side doesn't look like they're ready to fold up yet. They look like they're pretty comfortable. The other side won the case. And it was interesting because these guys are so confident at lunch. And I keep saying guys. It's not all males. It's males and females.
But it is a male-dominated field.
And I think one of the reasons is that whole male, I'm going to be better than you. I'm going to be bigger than you. I'm going to win more than you. I think there's a lot of that sort of male testosterone thing that hangs out there. One thing is, I'm going to go back to something. One of the things that we talked about is changing your testimony on the stand, and you don't change it really. You advocate your opinion. You're right. You go in there pretty well comfortable with where you're at. But if new things come up, they show a videotape of the client you said can't do anything, and he's working. They show. Well, then you shift gears. You have to go with what's presented to you. I've done that, and I've watched the attorney that hired me just almost want to crawl under the table.
Yeah.
And you think, well, that's it for many more cases with that guy or that girl. But later I've had them come up and say, we want to use you because that judge really thinks a lot of you.
That's right.
You know what I'm saying?
Yeah.
And so that honesty paid off in the long run. It wasn't a short-term game, but it was a long-term game.
Yeah, and you have to think that way because you're going to end up doing this more than once. I had a case several years ago where it was a terrible situation of a woman who got hurt on the job, and that wasn't an issue, and then had some really bad, I guess, back pain, if I remember right. And so they apparently, when they were doing the injections to manage the pain or cortisone or something in the low back, they hit a nerve, and she ended up looking like a person who had a right-sided stroke. Basically, she was hemiplegic, basically. And when I saw her, she could not use her dominant hand to write. She had kind of her hand was always like that. So she did mostly testing with her left hand, and the side of her face drooped. Really just like a stroke victim.
Right.
And she brought her estranged husband and kids, 2 kids with her to my office for testing, and I was really sad. She was a younger girl, obviously attractive, but didn't look it after having this tragic event happen. And a neurosurgeon testified that the injection that she got somehow affected the nerve and caused all this to happen. So I felt pretty secure when I took the witness stand. This is again in the Montgomery courts. after I went through about the first half of my testimony, we recessed because there were videos. And they showed me the videos, and the videos were of the claimant, the same girl. Oh yeah, when I saw her, she had a brace from hip to toe, one of those braces that keep toe drop from happening and all that. And, I mean, it was just a bad deal. And but they had videos of the girl over a 3 or 4 week period of time going to car lots with her husband and 2 kids, no brace, carrying one of the kids with her dysfunctional side, moving like you can't believe. I mean, she was absolutely fine. And it is the one time that I've completely flipped my testimony based on a video. Now, and that's another, it's a whole another class thing about surveillance videos. But my rule of thumb is that regardless of what the surveillance videos show, I usually don't flip on them because they don't show the whole picture.
I usually don't either.
And by that I mean many people can go out and do one thing or 2 things.
Right.
But what they don't show is that they might go home and have to go to bed or take extra pain medication or something like that.
Right.
So, but on this particular one, and it was taken over. I mean, there were a lot of factors in this case, but the case was referred over to prosecuting attorney for fraud.
For fraud, yeah.
Yeah, it was Judge Greenhall was the judge in that case in Montgomery, and she didn't take count of this lady doing that, and I didn't either because I kind of was. I really felt sorry for her, and you're gonna know what I mean. Rehab people like us, when we get in and we feel really a lot of empathy with somebody, and then we feel like we've been betrayed.
We were
used. It's a strong,
we were
strong
used,
feeling.
Yeah. And we've all been used in this business. Not much, hopefully, but we've been used.
Yeah.
I had one like that on the video. Speaking of video, where the big deal on the video was the guy said he always used his cane when he walked, and they had a video of him walking down to his neighbor's about 2 blocks down. He wasn't using the video. Of course, he was limping on one side. Not video. I'm sorry. Wasn't using his cane. So well, didn't that disprove all that stuff? Well, to me, it didn't. Right. I mean, it's a one kind of thing, shot thing. On the other hand, fortunately, I was the only time I've been on the right side of the case when this happened. Another one, the guy said, he couldn't bend, he couldn't walk, all these things, and they had pictures of him bending over, toenail in a frame for a house, and climbing and working on the roof, and they had great videos. Fortunately, on that case, I was on the side that thought he could work, so I just lucked out on that one. And actually, we were able to resolve that case very quickly before we got to court.
Yeah, usually when they produce those videos, that happens. That's another issue altogether as to whether or not they ever produce them.
Right.
Sometimes, what was the case that I'm trying to remember? There were videos or something taken. You can enter new evidence if it's used for rebuttal. I think that was in the "You Can't Handle the Truth" case.
I don't know.
Yeah. Anyway,
whatever.
That was a great idea.
Okay. All right. Sounded good.
So, but I want to segue over to jury trials.
Okay. Jury trials.
What I found is that usually I'm on the stand a little bit longer.
Right.
Have to give more background information.
You do?
About who we are, what we do. Most jurors, common jurors, don't even know what a vocational expert is.
They don't even know what rehabilitation is unless it's physical therapy. They don't have a clue.
That's what they think. And so, so what you want to do is give you want to do it quickly or succinctly, I should say, in terms of our background as a field. Most of the time, in terms of jury trials, I prefer to get up out of the box, either use PowerPoint.
Really?
I do. Or even a flip chart easel or overheads. Because my comfort zone is more being on my feet. And if I can get over close to the jury and sort of talk to them, it helps me establish a bond with them. Right. But it's up to, I leave it up to the lawyer. I mean, if he or she doesn't like that kind of stuff, then I don't do it. But if they do, I usually will do it that way.
I love jury trials, and I think what I love about them is you have an audience. And if you've done teaching very much, I'm used to an audience. I'm used to a group. I'm used to talking to people that I don't want to respond. I want to just sit there and listen. That's education, isn't it? Anyway.
Do you ever tell a jury after you've talked for a while, you ever say, this is going to be on a test? And then
I should. They probably would take notes and perk up. The jury is not allowed to ask you questions. So that puts them a little hamstrung. So what you've got to be sure you do is that you simplify enough of what you say that they can get it.
Mhm.
And it's easy to tell. You can look in their eyes
Right.
and you can see if they're getting it, not getting it, or asleep. I mean, I can tell right off. Yeah. There's always one like that. Always at least
Right.
one. Always one.
Or they're like this.
Yeah. That's it.
After lunch, it's really bad.
Oh, it is bad. It is bad. Matter of fact, you know you're not doing well when most of them look like
That's
that.
right.
You know it's not going well for your testimony. So, you talk louder, do whatever you can do to try to get them going. But I love a jury trial for that reason. And you always find some folks on there who are sympathetic to you, if not to your witness. I mean, to the claimant or client or whoever you want to talk about. And you can talk to those folks and really kind of get enthusiastic about it. And I find that the judges, I guess because the judges at that point, they're not making decisions.
Right.
The main thing they're doing is making sure that the procedures of the trial are correct. So they're a little bit looser sometimes about if you throw a little something humorous in there or you do something to kind
That's
of keep
true.
the jury with it. They tend
Yeah.
to kind of let it go. They
The
don't.
judges are looser in jury trials.
I think
it
they are
seems
too.
like.
And
With
again,
us,
it's because they're
anyway.
not making a decision. They don't have to be the one that decides. They just have to make sure it goes according to protocol.
Yeah, and I really view the especially in jury trials, the direct examination, which is the first part,
Right.
where the lawyer that's hired you is asking you questions. I always view that part of the testimony as just purely educational. I feel like I'm educating the jury as to what I did,
Right.
why I did it,
Right.
how it came out, and then how that influences what my opinions are.
Right.
And staying in a professorial role most of the time is very helpful to getting to your not getting beat up on the witness stand,
Mm-hmm.
which is a little bit different from being argumentative. And I've had problems in the past with really aggressive lawyers myself being argumentative.
Yeah. If you want to
And-
argue and fight
yeah,
with them,
yeah.
step outside, do
Yeah,
whatever.
yeah.
Well, one of the things that happens if you get if you're working, well, it doesn't matter which side you're working, but if you're working in the jury, you're kind of in tune with the jury, and you can tell they're doing nodding like that, they're taking notes. You can tell it's going well for you.
Mhm.
It's a little tougher for the other side in the cross-examination to attack you too much if they see the jury kind of likes you.
That's exactly it.
Because again, it's human nature things. The truth is the truth, and that'll win out. But also, people's feelings will enter into it too. So be careful, cognizant of all of that. Well, Mike, I hear the music coming in. Sounds to me like it's about time to wrap it up for this week.
Actually, before we do you
Yeah.
think maybe we could go take a look at a standard witness room?
I think we ought to see the witness room.
When you have a hearing, it's uncommon that you would just show up at the courthouse and go right into the courtroom. Most time you're going to be sequestered. Not all the time, but most of the time they're going to, when you get there, you might want to let the lawyer know you're there, but if the trial's already going on, which is the case in a jury trial, usually those things go on for days, you want to let them know you're there, but you go to the witness room. Right. And sometimes you might spend several hours in there.
All
I've spent
day.
a whole day.
Oh,
yeah.
it's miserable. It's a miserable day.
It's
Take work
awful.
with you. Read a book.
It is awful.
It's a long
It's
day.
usually a very sterile room. There's nothing going on. It's just awful. But what we'll do is let's go look at a jury room.
That'll work for me.
I mean, excuse me, a witness
A witness room.
Yeah, standard
A witness room.
Yeah, standard.
I might be mistaken.
Okay, so what we're going to do is go into the witness room here, and we're going to show you just what it's like. So I'm going to just check and be sure nobody's leaving right now. Oh yeah, so come on in. Come on in. So this is really the typical witness room. You know, sometimes you have to spend hours here. It's really boring after a while.
It is boring in here.
Yeah.
You know, it's just nothing happens much with fun, and I hate to spend the whole day here.
I would too. Hey. This is it.